Hi, good evening. This is Rahul Reddy. We are here live from REDDY NEUMANN PC every Tuesday at 5 p.m. Central Time. Along with me is my business partner, Emily Neumann. Emily, what do you have today, the news for this week?
Thanks for joining us this week. So last week we had the regulatory agenda for the spring that came out from the Trump administration. This is a spring and a fall that it typically comes out. It gives us kind of a picture of what to expect as far as new regulations in all kinds of topics, but we know specifically what is planned for immigration, so we'll talk about that. We're going to be talking about the delays that we're seeing with H-4s and the EADs that are filed along with them due to the new biometrics requirement. We'll talk about the resignation of USCIS's director, Cissna, and who the potential replacement might be and what that means for employment-based immigration. And then we'll talk a little bit about something that's called cross-chargeability. That is when you may have the option, if your spouse is born in a different country compared to you, you may be able to use your spouse's country of birth to get a faster green card than your own country of birth. So we'll go through a little bit of that and, of course, answer your questions.
If you have any questions, please don't hesitate to put those questions in the YouTube and also on the Facebook. We'll try to answer as much as possible. Emily, now the big topic about the Trump on the regulatory agenda, that they published that that they will be making some changes to the specialty occupation, and also with regards to the employer-employee relationship and control over the employee. Now, first I want you to explain what is a regulation and how does the administration pass the regulation and what effect will it have on the H-1B we will discuss afterwards, but I want you to run through what a regulation is and what is this regulatory agenda, and do they keep up with the dates that they have given, and if they keep up with the dates, when all these new regulations will become effective on the H-1B we are speaking about right now.
Yeah, so typically when Congress passes a law, it's kind of a broad brush, big picture kind of thing where they don't go into the nitty-gritty details. They say this is the policy that we want, this is what the law is going to be, but then they leave it up to the agency that has to actually enforce that law to decide how to implement it. And that's where regulations come in. So the Congress, when it passes a bill, is going to set out, for example, we want H-1B visas, and that is for people that will work in a specialty occupation. And that's it. That's all the law says. So now we need a regulation to interpret what exactly is a specialty occupation, who's going to get an H-1B, how are we going to give them out every year, what are the requirements for that. So the regulation is kind of interpreting what they think Congress meant, and that requires a regulatory process to change, meaning that before an agency, in this case Department of Homeland Security, can change a regulation, they actually have to publish a proposed regulation of what they're going to change, seek public comment on it, generally for about 60 days, review all of those public comments, and then come up with a final regulation that explains what they changed, what they kept the same, and what their kind of thought process is, and then the new regulation becomes final. So the regulatory agenda tells us over the next few months what regulations we can expect to see from DHS, and one of them is to revise the definition of specialty occupation. And they say the purpose of this regulation is to help ensure that visas go to the best and brightest, and that they're protecting American workers and keeping wages high. And so we can only imagine that the definition of specialty occupation is going to raise the bar, not lower it.
Now, I want to first come to the topic of the timelines that you expected, Emily. When it comes to the H-1B regulation, we're not speaking of H-4 EAD and other things, just the H-1B. When do you think so the timeline is for these things? Did they tell what the timeline is? Do they stick with the timeline? What is your expected guess on the timeline when the regulations will be finalized?
Yeah.
We'll go into the details of what regulations later on.
So they do give us a timeline for when they might propose the new regulation, and that's sometime in August of 2019. But then it has to actually go through the regulatory process. Now, just because they said August 2019 doesn't mean that that is when we will see a proposed regulation. These things get delayed all the time, more often than not. So we may see something in August. It may be later than that. I think that's part of why we're seeing a new director.
What's the minimum timing? What's the maximum timing that you're expecting?
So assuming that they were to actually propose this in August, usually a minimum time frame is 6 months, 6 to 8 months. It's not a fast
Six
process.
to 8 months after the regulation has been passed. And what's the maximum? Of course, there's no maximum.
Yeah, I mean,
Being an immigration lawyers, we never give maximum time.
yeah, looking at the H-4 EAD,
Now,
you can
coming
see-
into the new, the Cissna is gone right now, the DHS director. He's been considered to be the invisible wall. That's a nickname a lot of immigration lawyers. He's an invisible wall, not allowing people into immigration, into this country. Now, do you expect the new director to be any different or maybe better or worse than this guy?
Definitely even more of a hardliner on immigration. That's the reason that Cissna resigned, is because he wasn't hard enough on legal immigration, and definitely it's not going to get better.
So now, did they addressed only about specialty occupation and also employer-employee relationship? Right now, we have a denial ratings of 25% of the H-1Bs that have been filed, and most of them are because of the specialty occupation and employer-employee relationship and control of the employer over the employee. Now, what more these regulations will do? You're telling that Cissna, Director Cissna, he is the invisible wall, according to me, and you're telling the new director is going to be more harsher, and more harsher regulations are expected to come in. How harsh can they be? I mean, it's 25% denial for a lot of, it's the statistics given by the USCIS, 25% denial. How harder can it be?
It's anybody's guess, but certainly I think, especially with the employer-employee relationship aspect of it, one area where the government has really been focusing, they've been focusing their site visits, is the third-party placement or consulting firms, where the consulting firm hires the H-1B worker and then they place them at a client site. And the whole purpose of this employer-employee relationship type of request for evidence is to make sure that the company that's actually filing the H-1B visa is the actual employer, not the client site where the person is placed. And so I would expect that they're going to be looking even more deeply into the relationship between the companies as well as the individual, and really try to eliminate that model of business without coming out and saying you can't do that model of business, because I think that would be unconstitutional, but they're going to make it as hard as they can.
So you mean to say the target will be the consulting companies, especially all these big, small consulting companies. At least 50% of the H-1Bs or more of them are used by these consulting companies. Practically 70% of them are used. So they're going to make it unusable for consulting companies. Is that your prediction?
I think that's their goal. Whether they'll actually be able to do it or not is a different question, but that's certainly what their plan is.
Now, Emily, on the same regulatory agenda, they said that in May of 2019, they are going to eliminate the H-4 EADs. Today is May 28th. We have 3 more days. What is that going to happen right now? Are they going to pass the regulations on the H-4 EAD elimination, or are they going to take more time? What is expected of this?
Well, we're all kind of speculating here, but given that this agenda just came out, they would have had the opportunity to change that date if they wanted to. So the fact that they kept it May 2019 suggests to me that they still intend on following through with it. Now, will we see it by the end of this week? Maybe not, but I think they're close to proposing the new regulation that would eliminate the H-4 EAD. Now, just because they propose it doesn't mean that you can't file. It's just a proposal, but I do think it's coming soon.
Typically, we see all this bad news on Friday, Emily. And this Friday happens to be 31st. You reverse it up, it's 13th, which is a bad day. So I don't know if, because May 31st is Friday, and the reverse of 13. I don't know if something will pop up on the H4 EAD. Now, if there is a H4 EAD, what will happen to the existing H4 EADs? What will happen to the pending applications? Can we file an applications up to a certain time, or it's like all EADs are gone, just disappeared on one day? Will they issue a notification like that?
Yeah, definitely you can continue to file. Remember, this is just a proposal. So even if they do happen to announce it on Friday, it doesn't impact any existing EADs or those that are pending or those that are getting ready to file. You can still file. All the rules remain in place as is while the whole regulatory process goes through. So you can continue to file. It's not going to be an overnight thing where you wake up the next day and you no longer have an EAD. You'll have plenty of advance notice of what they're planning on doing and when it might happen.
Okay, so for H4 EADs, you can still file the extensions and still continue working if you have an EAD. Emily, you are telling that Francis Cissna has been fired or resigned, and he is the toughest person that I've ever seen as a director of the USCIS. And you're telling that he has been lenient on immigration, and the next guy is going to be tough? Mm-hmm. Ooh, that doesn't look good, Emily. Anything else on the before I go to this?
Yeah, I mean, there's a lot on this regulatory agenda that we were expecting. The public charge rule that was talked about several months ago. There was a proposal that wanted to look at your credit score and your salary and the number of people in your household and all kinds of different things to decide whether you would be inadmissible or not able to get even an H-1B, for example. So that final rule is planned to come out this fall. So lots coming in the regulatory agenda, none of it really.
Yeah, even though it might not be of a big of a problem for a lot of the business immigration people, however, the paperwork and the legal fees and all those things is expected to rise up, and a lot of extra burden, and the time that it's going to take to adjudicate all these petitions. They may even want to look into the IRS income tax returns before they even adjudicate. All these things might even take a longer time to adjudicate. So do expect more harsher things coming out from this administration. Don't expect anything good coming from this administration. Emily, on the topic of the green card, we know that people are waiting for a long period of time. Are there any shortcuts to it?
Well, there's one option, and that is if you are married to someone who was actually born in a different country from you, and this is called spouse cross-chargeability, meaning that you can use your spouse's country of birth to file your 485 if it would be a priority date current sooner. So that is one way that you may be able to slightly get a little faster, depending on your spouse's country of birth. If they're also from a backlogged country, then not super helpful. But
so, for example, if you're an Indian citizen born in India, and your spouse is an Indian citizen but actually born in Dubai, which is United Arab Emirates, you can be, the entire family can be considered under quota of United Arab Emirates instead of Indian quota. For example, you are from India, your spouse is an Indian national or born in United Arab Emirates. Then you can use that person. It's called cross-country chargeability. It's a fairly simple, there's not much paperwork to be done. So if any of your spouse is or you are even born outside India, I mean, you have a greater advantage. Right now, there's only two main backlog countries in employment based. One is India and one is China. So if your spouse or you are born in any other country, now you don't have to be a citizen of country. A lot of these Middle Eastern countries, they don't give citizenship when you're born in the country. So if you or your spouse born in any other country which is backlogged, you can use that country. It is the country of birth that will allow you to be a cross-chargeability. Now, don't get confused that if you moved from India to Canada and you got the Canadian passport, you could not be going into Canadian quota. It is the country of birth that will determine for your green card waiting list. It is not the citizenship that will determine which country you'll be charged to. So it's a country of birth, not the citizenship. Anything else?
Nope, I think
Let's go to the
that's it.
questions, Emily, on Facebook and YouTube. If you have any questions, please post it.
All right, one question from Facebook asked if an employer can sponsor an F1 student for the green card, file the Perm, labor certification, I-140, and 485. And the answer is basically yes, but there are some things that need to be taken into consideration when doing this. So basically, if you are in the country legally and maintaining your status, an employer could file a labor certification for you. Once that's approved, they can file the I-140, and then when your priority date is current, you file the 485. You don't necessarily have to be in H-1 status or L-1 status for that to happen. But you do have to be aware that there are certain visas that allow for what's called dual intent and others do not. Dual intent means that you can have the intent to be a non-immigrant and a permanent resident at the same time without impacting your current non-immigrant visa. The H-1B and the L-1 are both dual intent visas. The F-1 is not. That means when you're on the F-1 visa, you should have non-immigrant intent only. You should be intending to be here for your studies, for your program, and intend to return back to your home country when you're finished with that program. Now, they look at your intent at the time you're applying for your visa at the consulate and at the time you're entering into the United States. Once you're in the U.S., if you are finishing your studies and the opportunity arises, you may have the opportunity to change your mind and decide, you know what, I think I do want to stay here permanently. And the employer can file a labor certification. You can file an I-140 while you're still in F-1 status. Now you have to be able to continue to maintain your non-immigrant status until you can file the 485, because the I-140 does not provide you with any employment authorization or status. So that's something to be aware of. You may be limited in your ability to travel in and out of the country on the F-1 visa once you get so far into that process. But the practical answer is yes, you can be sponsored for the green card while you're in F-1 as long as it's done carefully and taken into consideration that issue of intent.
I have two good questions from YouTube, Emily. The second question is where I want your attention. The first question is that he got his H-1B approved. His wife did not get the H-4 approved. Can she go back to her home country and get the H-4 stamping without the H-4 extension, and she doesn't have the 797 approval? Andy, to your answer on the YouTube is yes. She can go back to the home country. She doesn't need the H-4 approval. She can show your H-1B approval. She can show a marriage certificate. That is enough. Of course, she has to prove that she's happily married with you. You all know what to do about that, but she doesn't need the H-4 approval for her to go for a stamping for the H-4. All she needs is a H-1B. Now this question, Shashikant's question, is the best question, Emily, that I want your attention on. His question is that he has a master's in computer science and he is going into the software industry. Why are they asking specialty occupation question?
Yeah, that's a great question. It's been coming up more and more. And the reason is the issue of specialty occupation does not look at your qualifications at all. The specialty occupation is where your employer must prove that your job that you're being sponsored for requires at least a bachelor's degree or higher in the specific field of study. So it's not questioning your qualifications. That's a different type of RFE that you would get, but it is questioning the job's qualification as a specialty occupation. Now the employer has to prove that it's an industry norm that that particular job normally requires at least a bachelor's degree in computer science, or that the employer has a history of always hiring people with at least a bachelor's degree in computer science for that specific job, or they can show that other employers advertise for their jobs saying that they require a bachelor's degree in computer science, for example, or there may be something complex or unique about this particular job that clearly shows that it requires that kind of degree. So what they're really questioning is two things. Maybe they think that the job doesn't require a bachelor's degree, it requires something less. There are some, IT people that could potentially do some jobs without a degree when you've got, 13-year-old kids building apps and all of that sort of thing. Maybe USCIS thinks that the job is not difficult enough to require a degree, or they could be questioning what specific degree field of study is required for that job. Maybe they think that you could do that job if you have a degree in computer science or math or engineering or business, or there's a whole list of fields that could qualify someone for that job. That could make them question whether it's a specialty occupation.
Ravikant has this very curious question. I understand why. Have you got any H-1Bs that are rejected in the lottery returned back to you, Emily?
No, we have not. Probably won't start getting those until mid-June, typically.
Puneet has this question with regards to the HR 392. Will this bill or any bill like this ever be passed? I hope it passes, but Puneet, I want you to answer this question to you. I've been in immigration field for more than 23, 24 years practicing. This bill, in one form or the other, was being tried to pass through the legislation, through Congress, many times. It has failed, I would say, at least 3 or 4 times, which is very close to get passed. In fact, in some form or another, it was passed in the Senate, but the House did not take it at one point of time. So looking into the atmosphere at this point of time, to be honest with you about the 392, it's not what I want, but to be honest, Puneet, I want you to plan your life assuming that this kind of thing, that the HR 392. Now, what he's mentioning is that taking off the per country quota limit that will get the priority date for Indian nationals to approximately 2016 in the first year, and maybe 2018 then in the next year. If I were you, Puneet, do not plan your life that something is going to be passed in the legislation, because the Congress has not passed any major immigration legislation from the past 35 years. So I would not expect any major legislation coming on it. I know it's a very minor thing, minor fix 392, but it's still, I do expect a lot of resistance coming from the Congress at one.
Mitesh and Srikant on Facebook both have similar questions about H-4s and EADs with H-1Bs in premium processing. So what I first want to tell you is that since the biometrics have been in play for the H-4, for every H-1B that we've filed in premium processing with the H-4 and the EAD along with it, we have yet to get an H-4 approval notice. The biometrics are all done. We filed these early on when the biometrics first came out, March 21st, and they are still pending. Follow-ups that we do with USCIS simply say these are being processed under the regular processing time for I-539s. They're not processing them in any kind of priority basis at this point. Short answer is we've not received any H-4 approvals from premium processing after the biometrics have come into play.
Not a single one.
Not a single one that I'm aware of. That being said, what we're trying now is to file in regular processing. If you're trying to get the EAD faster, file the H1, the H4, and the EAD in regular processing. Wait for the biometrics to be completed. Wait till the online case status says we've reviewed your biometrics, and then do the upgrade. We have a couple of cases that are kind of our test cases with that strategy that we don't have results on yet, but we're hoping that that will solve the problem. Otherwise, we don't have an answer at this point other than litigation.
Other than litigation, then you can, that's the only source, and you can contact our office. We're filing a litigation probably next week. You can join as a part of it. You'll have a concession price because we're going to group together all the people to file a litigation on the H4 EAD. I have heard, I have these other questions that are coming up on the H4 EAD in YouTube. Krupa has this question with regards to, she filed a H4 plus EAD in Vermont Service Center. When does she expect? It's taking between 12 months to 18 months right now in Vermont Service Center. If you have filed along with the H-1B, if you're filed before March 11, there is a probability that it might be approved along with the H-1B, but if you have filed it separately, we are noticing that Vermont Service Center is taking between 12 months to 18 months. Now, Emily has said that she has not received one single H-4 approval if it has been filed on or after March 11th. Now, we have also noticed that there are some H-4s that were being filed along with the H-1B, somewhere between January and March, that were not approved. Not all of them, but some of them were not approved. And we did contact the USCIS. They said that even though the spouse's H-1B has been approved, they don't consider those H-4s to be under premium processing. They're not going to adjudicate them along with the H-1B. Now, I'm not speaking a bulk of them, but only some of them between January and March 11th. But from March 11th onwards, not a single approval. Now, I've noticed that in one of the YouTube comments that some person has said they got the H-4 approval if it has been, not H-4 EAD, just H-4 approval when they filed after March 11th, but that is not our first-hand information. We only speak directly to the people and the information that we get it, and we are 15 lawyers in our office. If anything that comes up, or we speak as a consultation, we speak directly, that information will be relied, but anything that, that is rumored around, until we don't verify, we can't confirm it.
Divya from Facebook wants to know how long can you take a leave of absence while you're in H-1B, for example, for maternity leave or after maternity leave if you're not ready to come back to work? Can you do that? It calls into question whether you're maintaining your H-1 status. So typically if you're following your employer's maternity leave process and procedures and for how long they approve it, that time should be considered time in H-1B status, even if you're not working. But beyond that time, the longer you are remaining in H-1B status without working, even if it's after maternity leave, you could be found to be out of status. So you may need to consider changing your status at that point to H-4 if you have that option, and then changing back to H-1B status when you're ready to go back to work.
Ranjit has a question. His spouse and his kids, all of them got fingerprints on different dates. Can you bundle together, or do they all have to go differently? If you can go to the earliest possible appointment for the biometrics, 99% of the time they do take in all the people at the same time. Luckily, this biometrics is operated by private contractors, and they do work a little bit more efficiently than the government, and you can go. And if they reject the other person whose appointment is afterwards, it's not the end of the thing. You can go at the time in the schedule, and they will take you at that point of time. If I were you, I would put all the three people, take them together, and then if it doesn't work, I will take them again.
Ray from Facebook is currently on OPT, which is expiring soon, so he filed the STEM extension and now just found out his H-1B has been picked in the lottery with a change of status, and wants to know if he needs the cap gap, or what is the STEM extension going to be processed, what happens from here. So at this point, once your STEM extension has been filed and you already got that I-20 authorizing the STEM extension, you don't really need the cap gap anymore, because the STEM extension, the pending STEM extension, provides you with employment authorization for up to 180 days while it's pending. You don't need the cap gap. Now, if you wanted to withdraw your STEM extension and use only the cap gap, you technically could, but it probably would be better to stick with the STEM extension, because that continues your employment authorization beyond October 1st, whereas the cap gap does not. And if your H-1B is pending beyond October 1st, you want to be able to continue working, so the STEM extension provides you with that, whereas the cap gap does not.
This question is a little bit ugly for you to hear, Emily, but of course, cultures are different. I'm not going to name the person who asked the question. His friend married his sister's daughter, which is a niece, and when he went to the visa and he got rejected, what he's saying is that it is illegal in the place where he got married. What do you have on this one? We had a very lengthy discussion on this one. In fact, we published an article called Cousins Marriages, First Cousin Marriages. I want you to read that article. It also addresses with regards to the niece and uncle, and rnlawgroup.com. I'm a lawyer not only in this country, USA, but I'm also a lawyer in India where these marriages are legal. I know that. I'm a lawyer in India too. There are some issues with regards to the with regards to whether they can come into United States or not. If the first cousins are getting married, I would strongly recommend that they consult a lawyer. If it is a nephew and uncle and niece, that most probably, I don't think so. It's a workable deal. We tried to work, but it got nowhere, and they asked us to get an opinion from the state attorney general, and state attorney general was not willing to issue any good opinion on that. In the first cousin marriage also, approximately around 13 states in United States do allow the first cousin marriages, and most of the other states, if the first cousin marriage is valid at the place where it's got married, and if they move into the other states where the first cousin's marriage is not allowed, it's still legal if the place of the marriage is legal. However, when it comes to the immigration, they are interpreting it quite differently than if the marriage happened within the US citizens. So if immigrants are getting married, be proposing to live, all those things does matter. I would strongly recommend that they should consult a lawyer.
Raja from Facebook is currently on STEM OPT that is expiring in January and wants to know if the H-4 EAD might be an option because they're planning on filing an H-1B next year, but that won't be until filing in April with a potential start date in October. So you have to bridge that gap from January through October. The H-4 EAD currently is a good option. It should be a good option for the next couple of months until we actually have a final regulation. We don't know what that final regulation will say about already approved EADs. We're hoping that they will remain valid until they expire, which would give you enough time to file an H-1B and get that approved for next year. So if you are planning on staying in the U.S. while you file that, you should file it as early as possible to try to minimize the gap between the time when your OPT ends and the H-4 EAD begins, because H-4 processing times are so long when you file by itself. Otherwise, if you can file it with your spouse's petition, that would be a good option. But as we talked about earlier, you may need to consider filing in regular processing first and then upgrading after the biometrics are done to avoid that delay. Your other option is to go out of the US, apply for the H-4 stamp, and come back in, but that's going to give you probably a 4-month gap where you're not eligible to work while you're waiting for the EAD card, because you can only apply for the H-4 EAD once you're back in the US in H-4 status. So it kind of depends on how fast you want it, as well as whether you're comfortable or able to not work for several months while you're waiting.
Adlin has this question from YouTube. He's working with company A, he has his EB2 approved, he wants to move to company B. Can he move the priority date from company A from EB2 to EB1, assuming that your I-140 has been approved for more than 6 months or before they withdraw the I-140? Yes, the answer to your question, simply yes. However, Alden, I want you to take into consideration EB1 is not as easy as people think it is. If you're planning your life based on the assumption that here, EB1 is going to get approved, very similar to what you got an EB2 approved, I would want you to check with a lawyer before you make all these things. Being an immigrant, I understand, I want to plan my life. I have a family, I have a child, I have a house, I have a car loans, I have all these things. I want to plan my life. And if you're planning to think that EB1 is going to be like this, I may want you to consult a lawyer before you make any plans. I would tell you that in EB2 and EB3, the percentage of success is way above 90%. I mean, that's each case is separate, but way above 90%. When it comes to the EB1, it's way, way, way below the percentage of what I've given you for EB2.
Swapnil from Facebook wants to know how likely is it that USCIS will approve an extension of a B2 visitor beyond the first 6 months?
One thing is, I want you guys to be very careful when you're filing an extension of the B2. I understand the culture. I come from that culture. But here the culture is quite different. There's a reason why we left our country. The USCIS officers do not understand how the mother-in-law and daughter-in-law can stay together for more than 6 months. How the mother-in-law will visit the daughter-in-law and will stay with the daughter-in-law for more than 6 months. And vice versa, the mother-in-law living with the son-in-law too. For them, visiting 30 days and maybe not staying in the home all that period of time is very normal. Your mother-in-law or your mother, how long did she stay with you, Emily?
I don't think we made it 6 months.
Okay, so that's being said that we have noticed that a lot of B2s and B1s extensions are getting rejected. And the problem with that is that if your B2 or B1 gets rejected in the extension, the passport visa will become invalidated because you stayed longer than the I-94. So if there is a 10-year multiple entry visa, that becomes invalidated and she's not going to get the visa again if the extension, most probably, good chances that she's not going to get it. So I do not want you to risk your parents or your in-laws B2 extension. Don't do that. Even if you go to a lawyer, there's it's not going to make much difference. There's good chance you might get it denied. Now, under certain reasons, let's say for example, if somebody has a medical treatment, cancer, or whatever not, the medical things that happens with the people, yes, the USCIS is willing to, and if we provide the evidence, I don't think so any of the USCIS officer I've seen them denying the extensions, especially when we see, we're in the Houston Medical Center area, a lot of these cancer patients come, they stay like 1 or 2 years to get the treatment done. Never seen a rejection of the B2, but significantly, most of the B2 for visitors, for the parents, just because they want to extend, gets rejected in here.
Anvesh wants to know if a Perm labor certification can be filed while you're on H-4 EAD. Absolutely, no issues with that at all. That's a great option, especially if you've had H-1B in the past and switched to an H-4 EAD. Your employer can file labor certification I-140 for you, and then you could switch back to H-1B and continue extending your own H-1 beyond the 6-year limit. So that way, each spouse has their own separate H-1 and each is eligible to extend beyond the 6-year limit because you have your own separate Perm and I-140s approved.
Uday has this question: to avoid the complexities of the H-4 approvals and the EAD, can he just go to his home country, get the H-4 stamped and come back and apply for the EAD? Yeah, that may be a good thing that you may want to consider because of the lengthy delays that are happening. You have two possible. One is to go to litigation, and one is probably fly back and get the H-4 and come back and apply for the EAD. If you do have an EAD that is valid until, let's say, for example, 4 months from now or 6 months, in the case of when you're transferring from company A to company B, maybe even more than that period of time. Yeah, that may be a thing that I would consider. Litigation obviously has its chances, and money is involved in it, but this option is also a good option. I mean, you don't have to have a 797 approval to go and get the H-4 stamping.
Murali wants to know about a request for evidence on beneficiary qualifications for someone who's working in a software development type field but has a mechanical engineering degree. What are the chances of getting that approved? Well, typically in that situation, we would get a very detailed education plus experience evaluation that goes through your education and combines it with the years of experience that you have to come to the conclusion that you have the equivalent of a degree in the required field of computer science or MIS or something related that's more closely related than mechanical engineering. So it's typically going to be that evaluation that's going to be the most useful document that you submit. You have to be careful that the evaluation comes from a good service, because the evaluator has to meet certain criteria in order to be able to do that education plus experience evaluation. The school that the professor, it's typically a professor that does the evaluation, the school that the professor works for has to be one that offers what they call life credit for experience to their own students. The professor has to have authorization from the school to give this life credit, so they need a lot of extra documents to prove that the evaluator is authorized and credible, and then a good evaluation can help clear that type of request for evidence.
Raj has this question from YouTube. He has his I-140 approval. Is he assured to get the 3 years approval, or what are the probabilities, Emily?
No, there's the I-140 approval means you're eligible for up to 3 years, but the employer still has to be able to prove that you have 3 years of specialty occupation work available. So if they're extending your H-1B and your project is only going to last for 6 months, you might just get a 6-month approval regardless of whether you have an I-140 approved or not.
I have a question from YouTube here. He has his H-1B approved, change of status is denied. He went to India. He got a 221G. It's 4 months. I would like to evaluate the reason why change of status has been denied before I can comment anything more on it. There's a reason why your change of status has been denied. It may be a cause for your delay in 221G. It may be, may not be. I would want you to get evaluated by a lawyer, because it's not an easy answer. But in general, we have noticed that 221Gs in the consulate have significantly shot up in the past 2 to 3 years. One of the reasons is that delaying justice is denying justice. That's what this administration has chosen to, is they just want to deny justice. They don't want to rule. They don't want to even deny the case. They just want to delay it. If they delay it, you're going to lose a job. You lose a job, you're going to withdraw the H-1B application. So that's what they're trying to do in some of the cases. So,
one of the questions I had was about 221Gs. Can you kind of give us an overview of what exactly that is?
A 221G is that when you apply for the visa, when the consular officer feels that they need further information from either the employer, or they want to investigate more of those things, they will give a 221G. That means that after we further look into your case, we are going to evaluate it and we are going to decide your case. This is the number one problem of denials for the H-1Bs right now. Now, after the H-1B is approved, you're going to apply the application. The reason why this is causing a lot of problem is because if they delay it, you lose the job. You lose the job, you're going to withdraw the H-1B application. Any other comments? What's the reason why they're doing, Emily?
Yeah, it's definitely meant to delay. Obviously, once you're out of the country, the only way you can get back in is for them to adjudicate that visa and give it to you so you can come back. So it's just another way of them reducing the number of legal immigrants in the country, I think.
I'll go through very quick questions. Boomil has this question: can a H-1B visa holder start her own business? The answer is no. You cannot start your own business. If you want to own the business, it's different than starting your own business. If it is a publicly traded company, let's say, for example, the company that I like is Tesla. You want to own a shares of the Tesla company? Yeah, I mean, you can. I mean, you are the owner of the company. You don't need to consult an immigration lawyer. You're fine to own the company. But if you want to start your own company, that means that you're actually working for the company. So when you don't working for that particular business, you don't have a work authorization to work for that company. Your H-1B is only giving permission to work for the company that has the H-1B. And this other company that you want to start doesn't have the H-1B, you cannot work for that company.
Kushal on Facebook wants to know, by when should the H-1B cases be adjudicated? So I assume you're talking about the CAP cases that were filed in April. And the truth is, there's no deadline. They can take as long as they want. And I'll tell you, from last year, we still had cases pending from last year when we were filing this year's CAP cases. Now that was, of course, we didn't have premium processing last year until much later. So those that have the opportunity of premium processing, it's a great way to ensure that you get an answer before October 1st. But regular processing could go well beyond October 1st. There's no requirement anywhere that USCIS complete all the adjudication in time for your visa to actually start on October 1st.
Sam has this question: have you ever encountered a H-1B denial when it's filed in the consular processing when they are in the PhD program of Day 1 CPT? In general, we have noticed a lot of problem with day 1 CPTs. We continue to see a lot of problem with the day 1 CPTs. Have I encountered a denial? When you say denial, denial because you are on the day 1 CPT or denial in general? According to the USCIS statistics, there are 25% of the H-1Bs that are getting denied. For Capgemini, for example, there are 1,300 new quota H-1Bs filed, out of which 300 only 300 of them are approved and 1,000 got denial. So if you're going to ask me, have I seen a denial for the day 1 CPT who's in a doctorate program? Yes. Even if they're filed in the consular proceeding, yes. Is it because they're on the day 1 CPTs? Yeah, we have noticed some of them, but not a significant of them. We try to, by filing the consular processing, we're trying to avoid the issue of whether or not you're present legally in the United States, because that question is not presented. So most probably it might go through smoothly, but in general, H-1Bs have a higher percentage of denial compared to 2 years ago.
Speaking of consular processing H-1Bs, Shyam wants to know if you can transfer a newly approved H-1B filed in this CAP that's consular processing approval to another employer. You're not actually considered counted just because you got the approval in consular processing. In order to actually be considered counted in the CAP, you either need to be granted H-1B status through a change of status or receive the visa stamp in your passport. So until you obtain that visa stamp, it's not possible to transfer that H-1B. You're not considered counted. You have to go through the lottery again. So no, you cannot transfer unless you actually have the visa stamp.
Have you seen an increase in processing times of 485, I-131, and 765? Yes. I-131 and 765s that are filed with the 485 used to take only 90 days. Right now, I've noticed that they're taking about 150 days. 485s, before the interview process was there, and before 2017, it was only taking about 6 to 8 months. Right now, it's taking anywhere between 12 months to 24 months, depending on which district you are. Let me tell you one thing. In general, after this administration came in, the processing times have gone up by 80%, or am I telling something less, Emily?
Yeah.
Yeah, 80% processing times have gone across the board. And this administration has no intention to cut those timings right now.
Ananth from Facebook wants to know about filing a change of status from H4 to F1. You have to be very careful in this situation. So this is assuming this might be for an H4 dependent child who's reaching the age of 21 and continuing to study in college and therefore needs to change status to F1 to be able to do that. The processing times are so long that your school is going to have to keep deferring your start date for your F1 program. Every time they defer your start date, you have to have a way to continue your existing status to get up to that new deferred start date. So technically, this usually involves filing multiple B2 extensions in between. The last one I did, I had to file the I-539 for the change of status to F1, the I-539 for the first B2 change of status, and I-539 for a B2 extension, and then I got them all approved.
At the same time?
Yeah.
Emily, I choose now. I know you're a tough nut case. You like to take all the hard cases. I choose not to even file an F1. The reason is that it's frustrating to tell a client that, okay, I'm going to get you the F1 approval. This is a possible time. And that's 12 months. And then I tell, well, I told you 12 months, it's 18 months. Now here's, you have to file one more application. Here's the legal fees, here's the filing fees. Clients are frustrated with that. And I shy away from those cases because there's nothing you can promise them. There's nothing we can do to them. And sometimes it may be better for you guys to go outside the country and get the F1 approved, but of course they have their own risks involved when you go outside the country.
Good question from Nagarjun on Facebook. He's changing employers from company A to company B on H1. His spouse is on H4 with an approved EAD, and he wants to know if she can continue working on the old EAD from company A while the transfer is in progress until the new EAD comes in with company B. And in this situation, the EAD is still valid for some time. Yes, absolutely. You can keep working on the old EAD. Technically, it's not mandatory to even file the new EAD just because you're filing the transfer. That old EAD is tied to her H-4 status, which is tied to your H-1 status, not your employer. So you can be changing to different employers, and as long as you are maintaining some H-1 status with some company, she's considered an H-4 status and that EAD remains valid.
Sometimes the questions come from the YouTube, the obvious points we missed out, so easy things we should have informed. Sandeep has this question, whether his kids are born in United States, can he do the cross-country chargeability? Unfortunately, Sandeep, no, you can't. It's only the spouse, not the children. Even if they were born in a different country, like United Arab Emirates, Saudi, or something like that, no, you can't use the cross-chargeability if the kids are born in United States. Even if they are born outside United States also, it's only the spouse, not the children.
I have a question for you. Would you still recommend doing day one CPT considering the court case
Put a halt on it.
On the unlawful presence memo?
No, Emily, I would still not recommend anybody doing day one CPT. The court has put a temporary halt on it, doesn't mean that it's a complete okay. Now here is a couple of reasons why I still feel day one CPT. These universities are not conducting any classes. Now, when I say any classes, yearly 6 days of classes, I don't consider that as a classes. Now, YouTube and whatever not that you do still are not considered to be classes for me. Now you may say the digital age and all those things, I understand that, but the reason why you are in this country on F-1 visa is to go to the university. Now if you were to do the distant education, you could be in your home country and doing that. That's the number one reason. Number two reason, even if you don't believe me or you believe me, here is the reason why you need to trust that. Out of the 8,000 or 9,000 institutions that are eligible for the day one CPT, there are only 5 to 6 universities that are giving day one CPTs. And these 5 to 6 universities are all with only one particular national people are studying there. There are no Americans going to that school. And this is a big sign that might be a big fraud in those universities. The third reason is that these day one CPTs are conducting. When does the college start? Well, college starts in August, January, and sometimes in June for the summer semester. Now these universities are starting anytime you want. When does the college start? Whenever you want it. That doesn't look to be a genuine university to me. The admission requirements of these day one universities are surprising, Emily. Even I, with a law degree, can get an MS in computer science. I mean, that doesn't look to be, without writing any TLS, ELS or any GRE exam, I can get it. I mean, that doesn't look to be. So please believe me that these universities are not trustworthy. We have seen a lot of people getting deported, who have been turned back, and there's an article that I've written on it. I want you to go back to RN Law Group and the news section, search for it. People who are getting deported. One of the university guy, when he was trying to enter into USA, he couldn't tell to the CBP officer where his university, which city his university is. He couldn't name it. I mean, he has not gone to the university. He says, I've never gone to the university. At least can you name the city, at least the MSA? He forgot it. And they deported. So these are all good signs. The CBP officers are becoming very vigilant when you're trying to enter into the United States and when you're trying to exit. You're not going to get the passport visa on this university anyway. You already know that. So still, no day one CPTs, please. Student visa is not a work visa. It's only for studying.
Sri Vidya from Facebook, I think, gets the award for the best comment of the day, which is, the bottom line is all of this is just depressing.
Being an immigration lawyer, I've been an immigrant. I was on H-4. I came here. It's a different process. It's really, really, really depressing. But why do we have to present this, and why do we have to keep coming every week and present some of these things? Is that we want you to plan properly in your life, whether it's the immigration, whether in your life what you want to do, and give you the realistic picture what is happening. I mean, there are a lot of times people can say, yes, we can deliver all these things. I mean, give me the money, I'll get you H-1 approval. Of course, we can't do that thing, and we don't have the capacity to do that thing. So there are some realistic pictures I want you to. There are a couple of steps that you can do is that before your I-94 expires, if you would get the your visa adjudicated, you have a lot of other options. There are certain times you may want to get your I-140 approved as soon as possible. You may want to consider whether or not if the kid is becoming 21, you may want to plan well ahead of it. You may want to file an application 2 years ahead of it because you don't want to get the F1 adjudicated after, they won't adjudicate after the kid becomes 21. So all these things you need to plan in your life. You have to incorporate the immigration as part of your thing. And you know, I understand your frustration, but there's not much we can do. I mean, we just can give you the information. We are just the messengers, so don't curse us.
Sagar has a question on Facebook about EB-5, which we don't talk about a whole lot on here. Wants to know how long it takes for the I-526 approval. So EB-5 is the $1 million green card. That's if you are investing $1 million into a business, a new enterprise in the United States. You may eventually get a green card from that if you can show that you'll create 10 jobs for U.S. workers. The problem is the processing time just for the I-526 is about 18 to 24 months right now. The I-526 is kind of like an I-140. It does not provide you with any status or any work authorization or ability to travel. So it's just filing the immigrant petition. That's taking 2 years. Then, assuming your priority date is actually current by the time you get it approved, because there's no concurrent filing of the 485. You have to wait that whole time to get the I-526 approved, and then if the green card is available based on your country of birth, file the 485, and then that's going to be another probably year processing time, and all of that only gets you a 2-year green card, conditional green card. At the end of those 2 years, you file another application to renew your green card, remove the conditions, and get a permanent green card. That application takes 3 more years. So
Emily,
EB-5
you said
is
I-529 is 2 years, is that right, Emily?
yeah.
I want you to show the timings from the USCIS website.
Apparently I'm a little off.
Yeah, a little bit. It's actually anywhere between 30 months to 45.5 months. Now, if the video can get this one, this is from the USCIS site. Now, that's between 30 months to 45.5 months. Now, when the USCIS publishes the thing, it doesn't do it accordingly. It's always more than that time. I have gone to a lot of these EB-5, the Indian Association Assembly. People volunteer, kids coming in, you know, handing over. You get an EAD within 3 months. I mean, that surprises me that the I-529 requires to take anywhere between 2.5 years to about 4 years timing is what it takes. Until that period of time, you can't file an EAD application. Why are these people advertising saying that you're going to get an EAD within 3 months? I mean, please be careful. Of course, you know, you can get the advice from Emily, and we've written many articles on that, is that a lot of these agencies are going out of business and they're taking your money and running away. That's so simple. So be very careful on those things. Emily, now you said that after this, you know, you got a little bit off, 6 months off from the timing of the I-529, but after the I-529 is approved, until I-529 is approved, you can't apply the EAD. And after that, you file the adjustment of status. And you said the green card is only for 2 years? Mm-hmm. What do you mean green card is for green card is forever?
Yeah, well, this is a conditional green card. They want to make sure that the 10 jobs you've created actually are sustained and continue. So at the end of those 2 years, you've got to prove again that you made that investment, that the business is still operating, and that the 10 or more jobs continue to exist. So yeah, it is, and the percentage of people that go from the 2-year green card to the permanent green card is quite low when you look into the statistics. So it sounds great, $1 million visa, if you've got the money, go ahead, what do you have to lose other than $1 million? But it's not as easy as snapping your fingers and getting a green
I
card.
mean, to be honest, of course, there are 500,000 areas where the designated areas by the Department of Homeland Security that you can invest. But here is what the statistics, as Emily is pointing out, the temporary green card to permanent green card. Now, there's another statistics is that there are a lot of I-529s that get denied. To add to the statistics, from the start to finish, we see a success rate of 15 to 20%. Now, being an immigrant, if I were to lose all money that I have and I get my green card, I would be happy. Now, here is the problem. Some of these immigrants, they're losing the money and they're not getting the green card. So sometimes these people are buying is an employment authorization document for 2 years. So I would be wanting you guys to be very careful with your investment choices, with where you are putting your money, because that's very important. It's just, a lot of people get cheated in this EB-5.
All right, I think that's about it for today. Thank you all for joining. If we didn't get to your question, you can always join our daily conference call by going to rnlawgroup.com. You can find our schedule for that and the call-in number. We have an attorney every day that answers your questions for free there. And if you'd like a more detailed one-on-one consultation, you can get that information by going to rnlawgroup.com and clicking on consultation. You can see all of our attorneys' schedules and schedule that online. We'd be happy to consult with you on your specific situation.
And if there is any news that pops up, Immigration Girl, Emily does put it on the immigrationgirl.com. You may want to subscribe it because you will get the information and as soon as we get the news, we will put the language in which you understand it much better, and she posts that as soon as possible.